Senior Corporate Communications Analyst for Exterro, and I welcome you to today's webcast, Big Data Converging with Legal Information Governance and Regulatory Requirements. We'll get started in just a moment. First, a few brief reminders. All the lines have been muted to reduce background noise. We do encourage you to submit questions during the presentation. We'll do our best to work in those questions throughout the webcast. If we are unable to get to all of them, our speakers are more than happy to follow up after the event. This webcast is being recorded and will be posted to Exterro's website. In addition, a copy of the slides along with some additional resources will be available for download at the conclusion of the presentation. This webcast is being brought to you by Exterro, the pioneer and leading provider of unified eDiscovery software. The Exterro Fusion platform delivers a 360-degree view into the critical data and workflows required for defensively and proactively managing all phases of eDiscovery, from identification, legal hold, and early case assessment to collection, processing, analysis, review, and production. Presenting today will be Adam Cohen. Adam is Principal of the Fraud Investigations and Dispute Services Division at Ernst & Young, an expert in electronic discovery and electronic information management. Adam has more than 15 years of experience in law and technology, focusing on large-scale investigations and litigations, as well as proactive information management policies, procedures, and technology. He's a well-known author and lecturer in the field of electronic discovery and has served as a court-appointed expert on electronic discovery issues in federal court. Adam is a member of the Sedona Conference Working Group on Electronic Discovery and co-chairs the New York State Bar Association's Electronic Discovery Committee. He co-authored the treatise Electronic Discovery Law and Practice, which has been cited in landmark federal court opinions. He is also the author of the forthcoming book, Managing Social Media Legal Risk Through Corporate Policy, which will be published in March. Adam serves as an adjunct faculty member at Fordham and Pace Law Schools in New York, teaching electronic discovery courses. Joining Adam today will be Mark Melodia, a partner at Reed Smith. Mark leads the Global Data Security, Privacy, and Management practice within the Global Regulatory Enforcement Group. He's experienced in litigating class actions and other bet-the-company suits involving data security and privacy, mortgage and financial services, and other complex business litigation. Mark routinely represents clients responding to government privacy investigations, including before the Federal Trade Commission, the Office for Civil Rights, the State Attorneys General, and the United States Department of Justice. He frequently writes and speaks on issues surrounding privacy and other regulatory compliance concerns. And rounding out our panel is Adam Wells. Adam is Vice President of Business Development and Discovery Services at Terrace, with nearly 10 years of experience in the eDiscovery and litigation support field. Adam provides clients with strategic direction and best practice guidance on eDiscovery and information governance issues, striving to deliver a repeatable, defensible process to clients that ensures cost containment and risk mitigation. He frequently speaks on a wide range of eDiscovery and IG issues, from social media to defensible deletion. Prior to joining Terrace, Adam served as the lead eDiscovery project manager for a large national law firm, where he devised and implemented eDiscovery plans for clients, as well as crafted firm-wide eDiscovery guidelines and counseled attorneys on those procedures. Moderating today will be Bob Rolfe. Bob is Exterro's eDiscovery Counsel and Director of eDiscovery Strategies, with more than 20 years of operations analysis, professional services delivery, and litigation support experience. Bob advises the products team in the development of Exterro's eDiscovery software. Prior to joining Exterro, Bob managed business process improvement projects in a number of national and regional companies representing the transportation, energy, manufacturing, electronics, foods, and leisure sectors. And with that, I will turn it over to Bob, and he'll get us started.
Well, welcome, Adam, and Mark, and all of you who've joined us today, and thanks for being here. You know, the exciting part about being in eDiscovery is that every year one or two terms rise to the top of everybody's lexicon and becomes a center of attention. And while it's been around for a couple of years, the concept of big data has become the topic of the day at eDiscovery gatherings. The big data originates in the governance, risk, and compliance space, but has direct impacts on eDiscovery. Like many of the hot topics in eDiscovery, the term big data gets defined differently based on the point of view of the person doing the defining. So we'll spend some time today trying to clarify what is big data. And of course, it wouldn't be a hot topic if there weren't numerous problems associated with big data. So our speakers will explore many of those problems and then wrap it up with some suggestions for best practices in handling big data. So to start this off, you know, humans have always valued information, and I thought I'd start out with some interesting facts that might give a little perspective to today's presentation. So some of the first efforts to record and store data can be found in the caves of Lascaux, France. Over 17,000 years ago, natives documented star charts and details of hunts and spiritual rituals on the walls of caves. It's kind of a primitive storage device, but it was effective. The caves may have represented the sum total of stored human information at that time. In 1760 BC, the Babylonian king Hammurabi placed his entire set of laws on a stone block just a little over 7 feet tall, contained 282 laws. By the way of comparison, the U.S. Code of Federal Regulation alone takes over 19 feet of shelf space and contains almost 135,000 pages and 201 volumes. Hammurabi may have had it over us in terms of storage and concise the storage. But creating a copy of the Bible in medieval times took a month, over 20 years, basically a lifetime. Technology has improved that performance. In the 1500s, a copy of the Bible could be made on a printing press in just a little over 2 months. And then yesterday, just by way of curiosity, I downloaded a copy of the King James Bible. It took me less than 20 seconds. So in each case, the copy process resulted in at least a doubling of the volume of information that existed at the time. But now that I have a digital copy, I can attach it to email and send it everywhere without any kind of constraint. And storage needs have grown over time too. For example, the Library of Alexandria had a mission to hold the entirety of human knowledge, and it may have held as many as 40,000 books at the time. The Vatican Library has a similar mission and currently contains over 1.1 million books and 75,000 manuscripts. But the Library of Congress takes the cake, however. The largest library in the world, it has 74 terabytes of digital information already and holds over 142 million physical items, of which 32 million are actually books. Other items include recordings and photos and manuscripts and things of that sort. But there's a current effort ongoing to digitize information at the Library of Congress, and they're doing it at the rate of about 3 to 5 petabytes a year. So let's put this a little bit in perspective. 1 petabyte of information translated to a CD would create a stack of CDs almost a mile high. So you'd think with all these volumes that we're talking about, that would represent big data, but in fact it doesn't. So Mark, would you kind of help us get a grasp on what is big data?
Thanks, Bob. You know, you've thrown out some pretty big numbers, and the first thing to know about big data is it is big with a capital B. So let's do a few more numbers and then move on to some specifics and case examples of the ways in which big data is getting used. You know, 90% of all the digital data in the world has been created in just the last 2 years. And that pace is certainly not slowing. We seem to be applying a new version of Moore's Law, if you will. Some of the numbers, like the one on your screen right now, are just plain silly. And at least from a lawyer's perspective, you know, who went to law school to avoid math, you know, this is scary territory. But a few more numbers before we move on. 75%. 75% is the number of companies who use or intend to use big data solutions, according to IBM in a 2012 report. Now, quite frankly, I'm more interested in who's the other 25%. You know, who are they? You know, based on our own clients in a wide variety of fields, manufacturing, consumer products, banks, retailers, it's hard to imagine who the 25% is, and it's hard to imagine that number doesn't go down. One more number, and that's in connection with the Facebook IPO, there were a lot of numbers floating around last summer. And I raised that because, to me, the Facebook IPO and the discussions in the popular press around valuation and monetization of big data started to put numbers and a bit of a face on the big data issue for a lot of sort of ordinary people and, quite frankly, for a lot of legislators and a lot of regulators. And that's something we'll discuss as we move forward and talk about some of those challenges. So now let's flip over to, you know, really, where is all this data coming from? We know there's a lot of it. Where is it coming from? And I think, again, here, it may be easier to ask, where isn't it coming from? we've got a few examples up on your screen in terms of the obvious, such as your mobile device, a GPS device. At this point, the idea that locational data and other types of data is being shared with a wide variety of concerns, and that a lot of people want that data is pretty commonplace and understood. Less perhaps understood are some of the other ways in which data comes into existence. Some of it is intentional through social media and other express online activities where people want their expression to be seen by others. Some of it is unintentional. Sales transactions and things that you're doing online, searches which get captured, part of your digital footprint, part of the trail you leave behind as you go about your day. Quite frankly, not all of it is online. More and more of big data is being captured by the Internet of Things, sensors that are all around us, facial recognition, recognition of your car as you drive by. Those sorts of big data may not be the ones you read about when you read about the Facebook IPO, but they're very real, and it's a big percentage of the types of data we're addressing here.
Well, and I think, Mark, this is Adam Wells. I think also coming at it from an eDiscovery and information governance perspective, from behind the corporate firewall, one of the other things to think about, and really the elephant in the room as well, is this, what we're talking about here is mostly structured data, but I would want to point out that things get even more complicated when you add in, another component, and that is the unstructured data, such as email, which is at least behind the corporate firewall again is continue to grow at a very rapid pace.
Absolutely, and I think that the ways in which data is being gathered in not so much data sets, but in some ways data dumps in unstructured ways does make it even more of a challenge when you go to try to figure out what it is and how to start working with it. Just by way of one example, and then I'll hand off here to some other examples that others might want to share. A simple car like the Ford Focus, an electric car, generates just driving data for Ford engineers, to improve car design. Okay, that's pretty obvious. But also to utilities, to decide on choosing locations for charging stations, to traffic planners to speed up traffic flow. And then, of course, there are lots of folks who would like to have that data, insurance companies, personal injury lawyers, and others with an interest in what that data may show, whether it's individualized and personalized, or, as big data often is, in the aggregate and de-identified. So let's talk about some other examples of the ways in which data is being used and analytics. Adam?
Thank you. Well, let's look at three of the characteristics as described by Gartner. They talk about the 3 V's, volume, velocity, and variety of big data. And the question is, how do you get answers with such an incredible volume, velocity, and variety of data? And that's where big data analytics come in. You may have heard that term. And big data analytics are really referring to examining large amounts of data of a variety of types. That's the big data. And the point is to uncover useful information, hidden patterns, unknown correlations, and this enables some meaningful analysis that may be unavailable by conventional business intelligence means. It could include web server logs or internet clickstream data. Social media activity reports is a great example. And to see how this might work, you might think about social media as an example and how you could use analytics to look at policy compliance. You could look at personal use on company time or equipment, social graph extraction to identify and quantify contact with competitors, inappropriate political commentary. So there are all kinds of ways that you can use the special tools for big data to address a variety of problems. And you may hear about Hadoop and MapReduce, and these are technologies that have been developed to deal with big data. They are based on the realization that time to information is critical if you're going to extract value from all of these data sources that we identified before.
And Adam Cohen, I think that that's a sort of a great lead-in, the time to information. You know, in talking about probably the most widely known example of what I would call the big data conundrum, and you know, I think it's an episode that you know, a lot of folks are familiar with, and that's the Target baby ad episode, right? So, and I say conundrum because it's illustrative of both the upside and the downside of big data and real-time analytics, and that's frankly really why we're here today. So, the Target episode in a nutshell. Target, like many other giant retail operations, you know, they track each shopper and their buying habits through a guest ID number. Okay, that guest ID number links those habits to certain demographic information: age, marital status, income, you know, certain other shopping habits, and then they take that data, index it in real time, chop it up, you know, with the kind of statistical analysis that you speak of. And eventually they can predict shopping habits and foretell life events based on certain triggers. One of the triggers in this episode is you know, such as when a woman switches from scented to unscented lotion. That was a trigger that helped Target build a pregnancy prediction model, so that when a person's pregnancy prediction score reaches a certain threshold, Target can safely assume that this person will be susceptible to certain advertising cues that encourages her to purchase baby products. So about a year after Target created this model, a man clutching coupons and a mailer walked into a Target store outside Minneapolis and demanded to see the manager. The coupons that he held had been sent to his daughter, and they were coupons for maternity clothes, nursery furniture, other items. And he was obviously indignant and explained that his daughter was still in high school, and he expressed concern that these items would, in his words, encourage her to get pregnant. Now, you know, I think we all know how this ends. It turns out that the man's daughter was pregnant, that the pregnancy prediction model had accurately foretold that life event based on certain buying habits that the woman displayed inside a Target store. So this example, to me, again, it perfectly illustrates the crux of the issue. Big data is clearly useful as a business function, but what happens when that business function, right, crosses the line and leads to potential litigation or investigation? And so, Adam Cohen, I think, you know, in this Adam-to-Adam handoff here, I would ask you to talk a little bit about what this might mean for legal teams.
Yeah, unfortunately, I think unlike the opportunities in the business intelligence sense, most of the effects that we see, at least initially for big data, are not so fortunate effects. I mean, you know, with more data and more different sources of data, that's going to mean that it's harder to govern information, plain and simple. You see by the Target example that we have these major privacy issues. We also have security issues. It's just harder to govern and to do eDiscovery, as we'll talk about in a few minutes. There's more volume, more variety, things changing so fast. That means that there's more risk because the opportunity for missteps has expanded dramatically, and the technology is new. And that's another important issue because with Hadoop and MapReduce, as I indicated, those are open source types of technology, and we're very early in the game in terms of figuring out how those are going to play out in different scenarios. Not only are there higher consequences, you know, for failure, but these consequences are expanded dramatically, again, because of the volume. So any mistake is going to be amplified over a wider volume. And international issues are really exacerbated by this whole situation because a lot of this data, if not most of it, is in the cloud. And a lot of it is personal data of the type that is protected by various countries' data transfer and privacy restrictions. So, of course, what does this mean? Greater opportunity for high-volume mistakes. It's going to inevitably mean more regulatory and litigation events. And I don't need to explain to this audience why that's going to add up to greater costs.
So Adam, thanks. I'm sorry, I didn't mean to cut you off. Go ahead.
I was just going to pass off to you, Bob.
Okay, thanks. Well, that discussion certainly helps us focus on the fact that every silver lining has a cloud. Big data clearly has value from a number of perspectives. For example, having access to key data enables our intelligence agencies to puzzle out elements of a pending attack. It allows the marketers, as you discussed in the target instance, to identify and address customer needs. And it potentially could be used to spot and stop criminal activity. But as you started to discuss, there's obviously some problems that associate with big data. So, and in this webinar, we're particularly interested in those problems that come about in eDiscovery and compliance. So, Adam Wells, what are some of the preliminary issues that come up in a case that involves big data?
Thanks, Bob. So, I mean, of course, big data presents incredible discovery challenges. When we're talking about, again, here the Hadoop clusters that are going through and parsing this information, again, we're talking largely structured information. But big data, as I mentioned before, is also unstructured information. And so when you add those two together, especially email stores, which, as I mentioned before, are just growing exponentially, you've got a real tough task on your hands. It's one thing to have a data map for unstructured information, right? We can successfully map an email server and the custodians and the mailboxes, and we can understand where their office files are being stored on a server and do our best to construct a living data map. But can you have one for structured information that is changing second to second? I mean, this is, again, time to information is critical for the business function. That's also going to be a critical challenge for legal and discovery functions, right? So, we're talking about dispersed and distributed data locations. We're talking about a lot more data, right? High volume leads to sort of high opportunity for misstep, as Adam Cohen said. So, what happens when that data is subject to preservation? How will the indefinite preservation of this big data, of structured consumer information, how will that affect, that preservation affect the business's ability to mine that information for actionable content? Again, businesses are relying on real-time information, and they don't want to have a lot of overrun on that. So how much more difficult will it be, to sift through these data stores to find relevant information during discovery or just general compliance activities, right? What's the best way, once you've identified data stores, what's the best way to get that data out? Are we talking raw exports of structured information? Do we need the code behind the model? Will that one day be subject to litigation? So I would kind of throw this back to Adam Cohen and ask you, what can we do to be more proactive from an information governance, from a broad perspective, to address eDiscovery and compliance issues maybe before they arise?
Well, yeah, and there are some parallels certainly with eDiscovery. The developments that you talked about with respect to big data and eDiscovery, they fit right in with another emerging technology in the sense of predictive coding or technology-assisted review. There's just too much data for people to review manually. In terms of information governance policy, I think we have a similar development, and that is that we're going to have to rely more on technology because it's just too difficult to make decisions about individual pieces of information in isolation. So, you think about the kinds of retention policies that rely on individual employees to make decisions in terms of retention with respect to each individual email. I think most companies have found that those retention policies are unworkable and that they need to treat email more as a category. But, of course, that depends on how your business is set up. With the information governance, you're going to have to pay very close attention to your contracts with cloud providers or others who are handling your data. And, of course, that's more and more common as the data volumes increase and as these exceed the capability of a non-cloud provider to handle. You're going to need comprehensive policies over new data sources, whether they're structured or unstructured, like social media, okay, because we've talked about how many more risks there are in the sense that employees can now make mistakes that will be propagated all over the world instantaneously. So,
and Adam, it's Mark. If I could just cut in for a second, because your point on social media is such a good one, but may even by using sort of the plural media, it may make it sound simpler than it is, because if we think about the wide variety of social media sites that are out there and the diversity of information they capture and just how unstructured that is, your point about governance and retention really sings. You've got your general use social media sites, Facebook, Google, professional ones, text-based, visual, Instagram. You've got location-based, Q&A, debate, online games. I mean, all of that at this point becomes something that litigators are interested in. And yet, each of those sort of has its own challenges with respect to governance and preservation.
Yes, absolutely. So the importance of understanding not only each of those data sources, but the rules that are governing those data sources, like Facebook's rules, especially rules about privacy, which talk about how third parties are going to use all those different types of data that we talked about, and they're going to be propagated, as I said, all over the world instantly.
For Adam and Adam, a subject matter that kind of covers the last two slides we talked about. What about the new trend towards bring your own device, where personal data is mixed with corporate data, impacts on eDiscovery and policies companies should set up to try to govern that? Can you guys give any thoughts on that?
Yeah, well, bring your own device. Yeah, there's a lot of complications there, of course. But, these kinds of issues are always going to be driven by the users first. I've found that with just about every client, these kinds of trends are impossible to resist just because they create difficulties for compliance and policy adherence. So you need to have not only strict policies over use, but you need to have a way to enforce and monitor those policies. And when it comes to the kind of big data that we're talking about, you may not have good access to each individual device, but if people are accessing, for example, Facebook through their device, you may have access to it another way. Now, that's going to be complicated if it's password protected. A number of states have passed laws forbidding employers from making the surrender of credentials like usernames and passwords as a condition of employment. But the devices that are storing data locally, so they're essentially out of your reach from a centralized point of view, those need to be very tightly corralled by policy.
Yeah, and this is Adam Wells. I would agree with that, and I recently had a client at a large corporation tell me that in order for him to attract and his organization to attract the kind of prospective workers that he feels will help make his business successful. He and his colleagues really have no other recourse but to allow the BYOD kind of movement to take them over. And so, as both Mark and Adam have pointed out, there are real concerns there about how you balance that need, right? And again, this is the big data conundrum, writ large or writ small, however you want to think of it. How do you balance the needs of the business function, in this case, attracting productive, intelligent workers who are used to, having their own devices and not being governed, frankly, while at the same time keeping your organization compliant with rules and regulations that, at the state and federal level, but also that just protect your business interest as a company. And one of my clients told me, I dare you to to construct a data map that will handle all of our BYOD employees. And he said, frankly, it's a huge concern, and there's a lot at stake, sort of in the IT function as well, for information security. So it's a real challenge.
Well, if you came up to an answer to that one, I want to talk to you. Okay, so Mark, could we move on and start talking about regulatory compliance?
Absolutely, and it's in some senses, not moving on, or at least not moving too far away from where we've been, because the regulators in the U.S. and the rest of the world are focused on these complexities and the difficulties we've already been talking about, and a lot of the reasons that companies are struggling as hard as they are with these issues is to stay out of the glare of the regulatory system and to try not to be that limping gazelle at the back of the pack. This is a very dynamic environment, both legally, technically, and from a business perspective. From the legal perspective, just sort of this week's headlines, I think, drive home how hard it is to have a slide that isn't out of date as you type it. The FTC this week came out with major pronouncements warning mobile app developers and others about privacy-related issues, the idea of informed consent, and sort of the full panoply of consumer protection that it's been harping on for a long time, but clearly came out with a more specific set of pronouncements than it ever has in the mobile app environment just this week. I think yesterday Facebook announced it would accept sort of the self-regulatory icon as a way of trying to address the concerns that people have and its users have around control of privacy settings and control of who knows what about them, how can they use it, the whole idea of informed consent of the users. BlackBerry came out yesterday or today with sort of a technology-driven response to the same concern. In its app store, it's using technology to compare privacy policies on the apps in its app store with the actual data collection going on those apps. And it says it's shutting down the apps that don't comply. So there's pressure in so many directions, which is what the regulatory bodies have been after. It's what they've been trying to drive. And that, just in the U.S., and then you complicate it, obviously, when you go cross-border. Here in the U.S., it's complicated enough because we have a robust state and federal system. There is no single law of privacy, as you no doubt know. There is no one set of security standards, as you no doubt know. And so any company or any organization is looking to a variety of laws in the U.S. on a state and federal level. It can depend on what industry you're in and what type of data you're using. There are certain hot topics for sure. if you're dealing with children's data or location-based data or electronic health records, you are absolutely in the white-hot center of regulatory attention at the moment, but there's lots of other attention being paid. In the financial realm, you're dealing now with the CFPB, sort of the new kid on the block with respect to privacy issues. The FTC is certainly jealous of its turf in this area and its budget with respect to privacy enforcement, and isn't going to be left behind. In the healthcare area, the Office of Civil Rights enforcing HIPAA and changes to HIPAA through the HITECH Act, just keep coming. As was said, when you go cross-border, it gets all the more complex, and of course, it's not just sort of here and then there. There's no one other place. Most likely, our clients and you are operating in a global way, and of course, the type of digitized data we're talking about is inherently not national in scope. And that, of course, is the fundamental disconnect. Our privacy laws, and to some extent our security laws, look at things as if national borders matter to data. And as was said earlier, the cloud, as it becomes more important, really puts sort of that disconnect into sharp relief. There is no one set of laws that typically can apply to a single database when it's big data, because you have data subjects, where are they from, you have where the company is based, you have where it's operating. There are just so many possible rules and regulations that come into play. The EU certainly is driving the debate in the rest of the world. It, in fact, is debating within itself vigorously at the moment, trying to update its directive on data protection. It really has absolutely no clue right now what to do about social media. There's a real tug of war between the U.S., which, as tough as we are on privacy and consumer rights issues, the EU obviously is much more so, particularly in the privacy realm. And they are concerned with things like the right to be forgotten. Well, the right to be forgotten is sort of the polar opposite of big data. And yet they want to try to make that inherent human right part of a discussion about big data. How does that work? There's a skepticism in the EU about anonymized data. The big out of privacy concerns is typically that this is aggregated, de-identified data. It's anonymous. So who cares how it's being used? We can analyze it any way we want, the argument goes. But in the EU in particular, and increasingly in the US, with plaintiffs' lawyers and the FTC driving the charge here, there's a real skepticism about whether anonymous data really is anonymous. And that goes back several years, but has really stepped up in recent days. So let's talk about class actions too, because I mentioned plaintiffs' lawyers. It isn't just the government that is focused on these issues. I spend most of my day dealing with class action defense around privacy and data security issues. The initial cases were hundreds of cases that were brought around data theft and data breach. And as was said in the context of eDiscovery, the issues aren't different than they were pre-big data, except they're bigger. And the opportunity for mischief and the opportunity for potential harm to a larger set of people comes with the data set itself being bigger. And potentially, if there's more value in the data, the possibility of theft obviously grows as well. So security breaches and theft of data goes on. Most companies are very focused on perimeter security and trying to secure the border, as it were. Sometimes they're less good at paying attention to the people that work within their own four walls and the opportunity that either intentionally or unintentionally, the ways in which data can leak out. That's resulted in a whole lot of class actions around the country. I mean, just I myself have defended over 70 of those cases to give you a sense of how big that issue is. A second wave, though, of cases goes more directly to what we've been talking about here, what I would call the ick factor, the gag reflex that people have when they hear a story like the Target story that Adam told, or any of the other number of stories that we read about and experience in our own lives of being the subject of targeted advertising of one sort or another. That sort of data mining, analytics, the purchase and resale of data sets, those activities have given rise to a whole new wave of what I would call privacy-related litigation. And those have been centered around the use of flash cookies and LSOs on websites. And there you have cases in New York, California, and whole batches of cases in state courts like Arkansas and Missouri. The basic theory being not that it's illegal to do this, but in order to do it, you have to trespass on my computer. You have to drop code on my computer as a visitor to your website. And the argument is that in and of itself, that is trespass and is violative of the consumer's rights. In addition, they make privacy claims and unjust enrichment claims. Look, if you're going to use the data, fine, but it's my data, so I want to be paid for it. So there's a whole issue of ownership that remains very unsettled in U.S. law at the moment, but is very much in play in cases around the country today.
So, Mark, ultimately, do you see that coming down maybe as in terms of a social concern, the rights of business versus the rights of individuals?
For sure, Bob. It's the same battle we've had, and that I've spent 25 years dealing with in different contexts. You mentioned when you introduced me, mortgage-related class actions. It's the same set of rights. It's just who gets to benefit from the value that's being created, whose data is it, and are consumers being informed clearly enough about what is being done, with their rights, with their information, how it's being shared. Outside the U.S., there's a much more willingness to accept the idea that individuals ought to absolutely control this information, that it is their property right. That is not an accepted view yet in the U.S., but there are many who would like it to be. And if you think about a challenge to the basic business model of companies that are built around big data, and when you think about permissions to have information in a data set, or you buy a data set, do you need to be concerned with whether or not the individuals who are the subjects of that data set have opted into or given permission for that to be shared with you or used by you?
Okay, so thanks, Mark. I appreciate that. For people who joined late, I'd like to just reintroduce our panel today. We have Adam Cohen, who's a principal from Ernst & Young, and Adam Wells, a VP from Terrace, and Mark Melody, a partner at Reed Smith. So, based on the last couple of slides, Mark, it sounds to me like from an attorney's point of view, big data is more of a problem than it's worth. It might be a poor analogy, but perhaps we could liken big data to a wild stallion. In the wild state, it's magnificent, but no one dares to ride it. But once it's tamed, of course, the stallion becomes a prized possession with great value and utility. So, Adam Cohen, how do we go about taming the big data beast?
Well, first of all, I would say don't treat big data as monolithic. You have to consider the nature and characteristics of each different source of big data, for example, social media. You need to treat information governance now, and you did before, but now it's even more of an imperative. You need to treat it as a dynamic exercise. It requires ongoing attention. And whatever protocols you're developing, the rationale, the philosophy behind the new protocols or the modified protocols should be the same as what you were applying before. I mean, hopefully getting ready and dealing with electronic discovery will help you be familiar with the process here, because this is really an extension of the explosion in data volume. I think that in terms of these policies and protocols, they're worthless without monitoring enforcement. And the question is, how do you do this with all this data? But fortunately, we do have new technology in the form of these advanced analytics. And it's incumbent even on lawyers to understand that kind of technology. And of course, the lawyers need to understand the legal developments in order to make good policies, whether they're privacy or pronouncements from the National Labor Relations Board specifically about policies, etc. The idea of creating a data map, now we've heard about how difficult that can be, but it is essential. I think for the same reasons it is with non-big data electronic discovery. If you don't have a centralized repository of information, documentation of what your sources are, then you have no chance of complying with legal obligations like preservation and searching for relevant data and producing it, etc. So information about where this data is becomes very important. And it also becomes very important to focus on third parties like cloud providers or social media services, because you need to understand how their policies affect your data. International legal developments, same thing applies to what I said before. You need to do defensible deletion. A lot of people have given up on that when it comes to something like email, and they're just saving it all because they're so afraid of the compliance impacts of losing something relevant that's under a duty to preserve. But it's ultra critical here with big data that you dispense with unnecessary information that isn't covered by legal obligations, because if you don't, you will drown in data. Okay, certainly from a cost perspective, you will be drowning in data. If you're simply going to retain everything and you don't do any pruning, your legal costs are going to increase exponentially from the necessity of searching this data, collecting it, and producing it. So, people have to do a real risk assessment here. Is the possibility of losing something that may be relevant and subject to a duty to preserve, how does that balance against the incredible costs of maintaining these huge volumes of big data? That's what I would summarize, as some best practices for handling big data in terms of information governance.
Well, and I think as well, Adam, this is Adam Wells. I think as well for eDiscovery, those same best practices come into play, right? Earlier you pointed out the convergence of predictive technologies, in discovery review, and we're all talking about predictive coding and assisted review. And there's a convergence there with the predictive analytics that we're seeing being applied to these big data stores, and rightly so. And from an eDiscovery perspective, and not, obviously not to narrow it down, because eDiscovery truly is just a subset of a broader information governance policy, right? It is a legal and risk function that really can broaden out, and proper information governance practices, I would argue, can really make your eDiscovery procedures and protocol much more streamlined and much more in line with your with your business needs. So, but from an eDiscovery perspective, if you can use predictive technologies and models to mine structured consumer information and predict life events, certainly you can do the same thing and construct models that may help you anticipate litigation or regulatory events, right? It's all about the process, and I would argue in the same vein, you want to have all of the processes that we normally think about when we think about eDiscovery. You want to have a well-honed legal hold process, right? You want to be able to identify custodians of data, and in a big data world, who are the custodians? Who's responsible for all of that consumer information? That's sort of the first hurdle you have to get over. But once you do, how do you preserve it? How are you ensuring that, and this is something I mentioned earlier, once you begin preserving, these big data stores that are subject to legal hold, what do you do to scale up very quickly and ensure that you have enough storage media, frankly, to store all this? Can your cloud provider, if that's the route that you're taking, can your cloud provider scale up to meet those needs as well? So again, it's all about process. It's the legal hold, it's the preservation, and then it's applying very intelligent activities after that, including intelligent technology to really narrow down the subset of data that's going to be ultimately reviewed and then produced. And so I think from an eDiscovery perspective, you want to integrate as much as possible your eDiscovery protocol with a big data environment. I think that's extremely important. If possible, right? If the spend is there, invest in technology that's going to help you bring those tools to the source that can integrate across different systems. So, those are eDiscovery and information governance. I would say, and something I tend to get up on a soapbox about. But we need to think of these as not disparate activities, but really interrelated and activities that really we could say they're one and the same.
So Adam, along the lines of what you're talking about, obviously the growth of data is inevitable. I think companies are slowly starting to adopt policies to maybe manage some of the volumes, but do you envision predictive technology becoming almost a mandatory thing in the future to manage cases through eDiscovery?
Well, mandatory is is definitely not a word I would like to throw around, but I do think that it will, the companies that, similar to the companies that have adopted sort of, the predictive modeling on big data for a business function, right? These are the companies that are really leading an economic charge here. Similarly, I think those companies who use predictive modeling to help them, defensively remediate or delete data, to identify hotspots and trouble spots. I think those companies will, be at the fore of, really protecting themselves from a massive litigation or a massive investigation that, is monetarily something that, that scales to the amount of data that they're having to go through. So mandatory, maybe not mandatory, but really I think it will be extremely critical for companies to get a hold of it.
Right. I guess when I said mandatory, I'm thinking along the lines of just you get buried with so much data. The only practical solution is use technology effectively to cut through the chase and get to the things that actually matter.
Absolutely.
Okay, well, we're starting to run out of time, and I'd like to at least ask each of you folks, what would be the key takeaways. So let's start with Adam Cohen. I appreciate you sharing your information today. And what do you want our audience to take away from today's webinar?
Well, I would say don't be a deer caught in the headlights. There are technologies to help you, in other words, big data analytics, understand what those are and what they can do for you. And as difficult as it is, identify your sources of big data, document them, and have a plan for addressing each of them. I think if you do that, you will significantly reduce your big data stress.
That makes good sense. Thanks. So, Mark, what are your key takeaways?
Well, the Adams are covering so well the eDiscovery points. Let me go in a slightly different direction. Just some things that you need to be thinking about in connection with your customers or visitors to your website, and then third parties. So quickly, you need to know your changing obligations. You need to know what the FTC has said about people like you. You need to ask, am I a business associate today under HIPAA where I might not have been a year ago? You need to ask, what are people like me getting sued for in this area? If you can't answer those questions, then you're sort of just operating on luck at this point. Do you have a data breach protocol? Are you ready with the fire drill when that happens to you as somebody who is handling and collecting and perhaps using big data yourself? So that's about you. Your customers and your website visitors. It's about, as I was talking about with Bob earlier, transparency and choice. Typical consumer law issues. If you can demonstrate that there was some transparency and there was choice on the part of the consumer, your defense is going to be a lot easier. In other words, I'm trying to make my job easier for you right now. And then think, as you're thinking about developing new products or rolling out a new project, think about what I called earlier the ick factor. Think about how it's going to play in Peoria. How is this going to be viewed by a normal person? Just because you can do something with big data, doesn't mean you always should. And then finally, third parties. It was mentioned briefly earlier in the best practices section. I want to underscore it because when I think as a litigator about where the problems have come up for our clients, it almost always starts with a third party, and then it becomes somehow the company's problem. There's almost always another party involved, a vendor. And at this point, there's enough history out there to look and say, who do I want to stay away from? Who is just too hot to handle right now? Who's in the sort of the crosshairs too much? Can I get that same product somewhere else in a way that might be lower key? What does my contract say with them? Indemnification provisions. And then finally, if nothing else that we've said sticks, or at least nothing else that I've said sticks with you, insurance. If all else fails, let's try to get somebody else to pay for it. So think about your coverage in connection with all of these events, your activities involving working with big data and any storage issues, breach issues, business interruption, all of the things that can come into play when big data is involved. You might be able to get coverage for such losses, but you need to be thinking about that ahead of time.
Those are great points, Mark. So Adam Wells, what do you want to leave our audience with?
So I'll just say pretty quickly here, I think that this topic is one that, it can instill fear in people who are thinking about this, the big data issue, and who are just starting to tackle it. And I don't think that that's necessarily an inappropriate response. I mean, I think that some fear is always a good thing. But if I could just maybe end this on a positive note, challenge the challenge that big data presents. I think it really also is presenting an opportunity, and it presents an opportunity for folks inside of a corporation to really become even more useful and valuable to that corporation when you start to champion this idea of how are we going to protect ourselves legally in the big data era while still driving that business function. And I see a number of folks in the information security line of work who are really starting to think about this and really trying to drive change inside their organization, and they're finding that while it is a challenge, it's also a real opportunity for them to again add some value back into the organization, even more so than they do on a daily basis. So it's not all cloud to a silver lining. I think that there's some opportunity for some really interesting and intelligent solutions, and the folks who can bring those to bear are going to really lead the charge in our new big data environment.
Well, thanks for helping us finish on an upbeat note, Adam. Now I'm going to turn the controls over to Andrew Bartholomew to wrap this up.
All right, thank you, Bob. As we learned today, big data presents a number of eDiscovery and information governance challenges. Compared to the past, when eDiscovery requests typically involved only a handful of data sources, organizations today are faced with an exponentially growing and increasingly decentralized data environment. As today's discussion reinforced, meeting the challenges of big data requires more sophisticated processes as well as more advanced technologies. One of the unique things about Exterro Fusion is that it's really the only eDiscovery platform designed specifically for enterprises seeking to bring eDiscovery and information governance in-house. And an example of how that translates into the actual design of the product, the Fusion platform supports more than 65 connectors for crawling and collecting ESI from various data repositories and third-party sources such as archiving, document management, and content management systems, and even cloud sources, and brings all that ESI into a centralized vault. Last fall, Exterro became the first and still only software provider to provide advanced predictive capabilities across the entire eDiscovery lifecycle in advance of ESI collection and review. And building on that, just last month, Exterro launched Fusion Automatic Document Categorization, which applies advanced analytics to assign predefined labels or tags to documents at the time of collection. Legal teams can leverage these technologies for identifying relevant ESI sooner, making better informed case strategies, reducing collection volumes and associated costs, and also for compliance purposes, such as uncovering sensitive documents that contain personally identifiable information or protecting documents that are likely privileged. Those are just a few examples of how Exterro is actively addressing the big data challenge. We encourage you to learn more at exterro.com. Thanks again to our speakers, Adam Cohen, Mark Melodia, and Adam Wells, and to our moderator, Bob Rolfe, for leading today's excellent discussion. You can download a copy of today's presentation and access additional resources via the link provided on the screen right now. We will also be posting a full on-demand recording of the webcast to that page. Just keep in mind that it usually takes us about 2 hours to process the recording and get it fully uploaded to the site. We would really appreciate if you would stick around for just a minute or so and fill out a short survey about today's webcast, which will appear on your screen in just a moment. Thanks again, everyone, for joining us, and have a great rest of your day.